सेंट सोल्ज टाइम्स देखਣ ਵਾਲੇ ਸਾਰੇ ਹੀ ਸਰੋਤਿਆਂ ਨੂੰ ਮੇਰੇ ਵੱਲੋਂ ਯਾਨੀ ਕਿ ਤੁਹਾਡੀ ਆਪਣੀ ਕੋਮਲ ਸ਼ਰਮਾ ਵੱਲੋਂ ਪਿਆਰ ਭਰੀ ਸਤਿ ਸ੍ਰੀ ਅਕਾਲ। ਅੱਜ ਅਸੀਂ ਪਹੁੰਚ ਚੁੱਕੇ ਹਾਂ ਜੀ ਸੇਂਟ ਸੋਲਜ ਲੋ ਕਾਲਜ ਦੇ ਵਿੱਚ, ਜਿੱਥੇ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਰੱਖਿਆ ਗਿਆ ਹੈ, ਜਿਸ ਦੇ ਵਿੱਚ ਬਹੁਤ ਸਾਰੀਆਂ ਟੀਮਾਂ ਅੱਜ ਆਪਣੀ ਪ੍ਰਤਿਭਾ ਨੂੰ ਰੋਸ਼ਨ ਕਰਨਗੀਆਂ। ਤੇ ਆਓ ਫਿਰ ਦੇਖਦੇ ਹਾਂ ਜੀ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ।
Former Judge of Punjab and Haryana High Court. Our student coordinator presenting bouquet to our worthy Honorable Chief Guest, Honorable Justice M.S. Chauhan Ji, former Judge of Punjab and Haryana High Court, worthy Chairman Sir Dr. Anil Chopra Ji. And I welcome you all on this Moot Court competition. I request our worthy guests to pay homage to our respected Shri R.C. Chopra Ji, founder of Saint Soldier Group of Institutions.
Honorable judges who will be presiding over the proceedings of today's Moot Court competition, Honorable Justice M.S. Chauhan, Honorable Justice Kuldeep Singh Ji, and our worthy Chairman Shri Anil Chopra Ji, the judges for the semi-finals, Shri Nangali Saab, so former District and Session Judge, Professor Dr. Pawan Kumar Ji, Professor and Head Guru Nanak Dev University Amritsar, Dr. Manoj Sharma, Associate Professor Rajiv Gandhi National Law University Patiala, our worthy Managing Director Professor Manar Arora Ji, Veena Dada Madam, the principals of our respective colleges from Engineering College, Pharmacy College, our Director Sports and other faculty members, dear students. This Moot Court competition started yesterday with the cooperation and guidance of our this management, with the chairman Shri Anil Chopra Ji, and our colleagues. They made the effort, and we felt blessed that yesterday Honorable Justice Kuldeep Singh Ji, he inaugurated this Moot Court competition. So far as Justice Kuldeep Singh Ji is concerned, yesterday he made a brief reference about his lordship. So he started his career from the species judicial, that means judicial magistrate first class, going up to the level of High Court, enjoying different capacities and leaving a mark behind. So in the capacity of CGM, Additional District Session Judge, District and Session Judge, and also as the Judge of the High Court. So wherever his lordship worked, he left the imprints. So quite obviously, and sticking to the integrity which is expected of a judge in true sense, so that was there. So Justice M.S. Chauhan, so basically he started with the legal practice as an advocate. So then a step further. So Justice M.S. Chauhan was in that category. He joined the judicial services as additional district and session judge. So then rose to the positions, enjoyed that apart from the after superannuation from Judge of Punjabi Channel High Court. So his lordship was this appellate tribunal for police services, armed services. Yes. So we find that this Justice Chauhan, because it has been quite 3 or 4 times that we had the occasion to just interact with his lordship, we do find and appreciate that the qualities of his head and heart, so that are there, you will find beside person he is there. So that means having the academic interest. Whenever we just approach his lordship for any kind of favor, for presiding over, maybe online, it can be offline, so he has always obliged us. So sir, on behalf of the management, on behalf of the college, on behalf of our faculty and students, we welcome you, both the lordships. So we feel privileged, and I am sure even the participants, so coming across the country, so the teams are there. So yesterday we had 3 rounds, and today will be 4 rounds. 4th round has been completed. Semi-final, not the finale, that will be there, which will be presided over by these 2 lordships. So far as this problem is concerned, making the observations after the proceedings are over, his lordship and both the lordships, they will just share their views. But we found a reason for it. Normally the moot problem used to be of traditional type, sticking to the criminal laws or the family laws, so forth.
So, St. Soldier Law College bring forth its 11th R.C. Chopra Memorial National Moot Court Competition 2023. There were 32 teams from the different parts of the country who went through preliminary round. 16 teams got qualified, out of which 8 were selected for quarterfinals, and out of these 4 teams, 4 got into semi-finals. Today in the morning, semi-final round was conducted. Now for the final round, we are having 2 teams, RC 502, RC 507, and these 2 teams have proved that if you are willing to learn, no one can help you. If you are determined to learn, no one can stop you. With these, I request both the teams to come forward for the next round. Now, I request Professor Rohan Sharma ji to come forward for the draws. Justice Kuldeep Singh ji and Honorable Justice M.S. Chauhan ji, that is before division bench. Our team RC 507 will proceed from petitioner side, and team RC 502 from respondent side.
The council is appearing before the Honorable Court in the case of Prakash Raj and others versus State of Kamla on the behalf of the petitioner under Article 32 of the Constitution. Your Lordship, there are 4 main issues involved in the case. The council will be addressing first and second issue and will be taking 20 minutes, and my co-counsel will be addressing third and fourth issue and will be taking another 20 minutes. Didn't explain the urgency of those appointments, and after some days, the 4 ministers headed by Shri Prakash Raj also held the press conference and criticized the government for being the puppet of the central government, and they also made the derogatory remarks against the wife of the governor. And after that, governor removed all the 4 ministers. Aggrieved by this, the minister approached the Supreme Court, and one petition has also been filed by the governor against 10 appointments by the state government. The council seeks permission to begin with the pleadings. Much obliged, Your Lordship. The order of the governor is liable to be struck down because the decision is arbitrary, discriminatory, and clearly to seek revenge. He has removed the ministers because they have passed a bill to take away the powers of appointment of high officials in the State Public Service Commission and other state bodies such as vice chancellors of state universities, chairmen, and other members of the state bodies. He did so because the state of Kamla has tightened the screws on him the power of governor was withdrawn by the state of Kamla because state of Kamla believes that the office of the governor has its roots since the colonial period. And also, your lordship, the order of the governor is liable to be struck down because it is unreasonable and violates the provisions of the constitution. One of such provision is Article 163 of the constitution, which states that the governor shall exercise his functions according to the aid and advice of the chief minister and council of ministers. And also it violates Article 14 of the constitution, which states that the
Written as by referring to the particular article of the constitution,
in which regard, sir?
powers of the governor vis-a-vis removal of a minister or appointment of a minister.
It is Article 164(1) of the Constitution and Article 163(2) of the Constitution, your lordship.
Can you read it?
If we accept, we want to interpret this provision. If we accept the position which is written here, it will convert the governor into all-pervading super-constitutional authority, and the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature.
The constitution says his decision is final.
It has to be harmoniously construed with other provisions of the constitution as well, your lordship, like Article 163 clause 1 of the constitution, which states that the governor shall exercise his functions according to the aid and advice of the council of ministers and chief minister, your lordship.
If the governor is the appointing authority of a minister, we feel that he has the power to remove also. How do you come out of it?
Lordship, here we want to mention the Article 164 clause 2, which states about the collective responsibility of the council of ministers to the legislative assembly, and by interpreting that we have interpreted that they are responsible to the legislative assembly. In that case, legislative assembly has to be the authority which can remove, and also it is the nominal head, and the real head are chief minister and the council of ministers, your lordship.
That way you mean to suggest that a minister can be removed from office by the legislative assembly? You mean this?
If they have on some grounds, your lordship.
Your argument is that minister is responsible to the legislative assembly or the parliament, as the case may be.
Yes, your lordship.
By that you want to say that legislative assembly or the parliament has power to remove a minister from the office? Yes or no?
Yes.
One example.
Your lordship, I didn't remember the example, but if the chief minister, sorry, your lordship.
Your lordship, issue number 3 states whether the governor is only assigning authority or does he play an active role in a parliamentary democracy. The petitioner most humbly contends that the governor is just assigning authority and he does not play an active role in a parliamentary democracy. Your lordship, the parliamentary or the cabinet system has been adopted by the Constitution of Maurya. The parliamentary democracy and the cabinet system by its very name suggests that the governor and the president is the nominal head, and he has to act with the aid and advice of the council of ministers and the chief minister. That has been expressly provided under Article 163 clause 1, your lordship. In this particular article, he has the power to address and send messages to the House of Legislature. He has to do so on the aid and advice of the council of ministers. The petitioner contends that even though Article 168 states that there shall be a governor of state, the fact of matter is that the governor has no role to play in a legislative activity. Everything he does is under the aid and advice of the ministry, your lordship. Your lordship, in this particular case, it was clearly set out that the governor cannot employ his discretion and he needs to strictly abide with the aid and advice of the ministry. The concept of responsible government was also highlighted in this particular case. The parliamentary system, by its very definition, establishes the responsible government, and the governor cannot cannot be stated above the real executive, that is the council of ministers, your lordship.
Do you mean that the governor is merely a rubber stamp?
Your Lordship, we are not saying that he is a rubber stamp, we are saying he's a nominal head. In this particular case, in the present case, Your Lordship, he has dismissed the 4 ministers. He does not hold the power to dismiss the ministers under his discretionary power.
That is a different issue. But does the governor have any discretion in certain matters?
Yes, Your Lordship, certainly yes, he has discretionary powers, but that too is limited, that too in a limited scope, Your Lordship. Under Article 163's Clause 2, he has discretionary power, but that is, he has 2 kind of discretionary powers under Article 63's Clause 2, constitutional and situational. And in constitutional situation, there is no way mentioned that he can remove the chief ministers. For the ground that has been stated in the Moot proposition that the ministers has disgraced the modesty of the office of the governing lordship.
That has been argued by your friend. You have to argue on issue number 3 and 4.
Yes, Your Lordship.
There is one article 356 in the Constitution. It says that in case of failure of constitutional machinery in a state, the governor can recommend to the president dismissal of the state government and bringing the state under the president's rule. If four ministers come to the office of the governor, rebuke him, call him bad names, can't he recommend dismissal of the government to the president under 356?
Certainly not.
It is not failure of constitutional machinery in the state.
Your Lordship, in this particular case, we are contending that he did not have the power to dismiss the 4 ministers.
No, we are not talking of dismissing. He can recommend to the president, he can send a report to the president that constitutional machinery in the state has failed and president's rule should be imposed on the state.
Your Lordship, to my view, the point here is that Article 356 can only be invoked when there is a failure or collapse of the constitutional machinery in a particular state, Your Lordship. In this particular case, there is no failure of the constitutional machinery, Your Lordship. He has disgraced the authority. It may be personal.
The ministers, we understand, are there to run the state according to the constitution, according to the laws, and this is none of the duties of a minister to call bad names to a governor, to rebuke a governor, to humiliate a governor. That way they are not adhering to the duties assigned to them by the constitution. And would it not mean that constitutional authority, constitutional machinery has failed? They are not abiding by the constitution?
Certainly not, Your Lordship. In this regard, the personal disgracing has been done to the governor's office. There is no public disgracing in this particular case, Your Lordship. We cannot invoke Article 356 in this particular case. Your Lordship, the governor in this particular case has himself filed a writ. The respondents has filed a writ, and we are contesting that the writ that has been filed by them is not maintainable.
Why?
And we are referring to Article 50, separation of powers from the judiciary.
We are not on separation of powers.
Yes,
We are on Article 32 of the Constitution.
Yes,
Read Article 32. What does it say?
Your Lordship, Article 32 provides remedies for the enforcement of rights which has been conferred by this particular part, Your Lordship. The right to move to Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Your Lordship, in this particular case, no fundamental right has been violated. If he has any alternative remedy, that is by way of defamation under Section 499.
What is writ of quo warranto?
Your Lordship, quo warranto is by what authority? So you can question public authority how they held the office and...
Governor cannot question that quo warranto. Can or cannot?
Your Lordship, he cannot.
He cannot. So he has no resort to Article 32 of the Constitution as far as illegal appointments are concerned.
Your Lordship, that's what we are trying to contend with this particular.
Thank you.
The council seeks permission to refer the bench by Your Lordship. Much obliged, Your Lordship. Your Lordship, first we would like to apologize for any errors which has been made in the written submission and we will make at most endeavor to rectify this.
Why should you presume that errors are there?
It may be the grammatical errors. We should much obliged, Your Lordship. Your Lordship.
That would mean that you yourself are not very sure about the accuracy of the submissions made in this compendium or whatever you call it. Why should you apologize at the very outset? You make your arguments, let's see if there are any mistakes, then we'll call for your apology, then you may not. Why should you invite our attention that there are mistakes in the memorial submitted by you?
Indeed, Your Lordship.
Anyway, proceed.
Much obliged, Your Lordship. Your Lordship, the Council seeks permission to proceed with the statement of jurisdiction. The petitioner has approached the court to try and entertain and dispose of the present case by virtue of Article 32 of the Constitution of Moral. The respondent humbly denies the jurisdiction under the petitioner has approached the Honorable Court. The Council seeks permission to proceed with the statement of facts. Indeed, Your Lordship. Indeed, Your Lordship. The Council seeks permission to proceed with the issues. There are 4 issues in the composition. The first one and the issue 2 will be dealt by me, and the third and fourth issue will be dealt by my co-counsel for 20 minutes, and I will be dealing for the 22 minutes. Much obliged, Your Lordship. Your Lordship, the Council seeks permission to proceed with the arguments. Much obliged, Your Lordship. Your Lordship, the jurisdiction of Supreme Court, being the apex court, he enjoy very much power, but in this instant case, he cannot encroach the ambit of the governor, since the separation of power is the essential features of the Constitution. The Supreme Court jurisdiction are as follows: the power to commit a person for its contempt under Article 129. It has original jurisdiction to interfere in the intergovernmental dispute under Article 131. The Supreme Court has appellate jurisdiction under Article 132 to 134. The Supreme Court has very extensive appellate jurisdiction under Article 136 in the name of special leave petition. The court has also the power to review its own decision, and the court also have the power to pass any decision for doing the complete justice, and it has been provided under Article 142 of the Constitution. And being the executive head of the state, and during which pleasure the ministers means continue to hold his office, he can.
Where do you get that governor is the executive head of the state? Can you point out the relevant article of the Constitution?
Indeed,
It says that governor is the executive head of the state.
Article 153 of the Constitution of Moral.
Read it.
Power has been provided under Article 154, and the language is that the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through office subordinates to him in accordance with the Constitution. Lordship, if we go with the Article 164 of the Constitution, can I just read that provision?
You know, the simple question is Article 154 independent of Articles 163 and 164, or it has to be read along with those articles?
Your Lordship, it has to be read with the other articles which you have mentioned.
Hello. Suppose some appointments are made or removals are made against the Constitution by the governor. Whether in that case the Supreme Court has got the power to intervene? Suppose that I give you one example, that anybody can hold the office of minister for 6 months without election. After 6 months he lapses, but the governor again appointed him minister on the advice of the state government. Whether in that case there is a fraud on the Constitution, the Supreme Court has the jurisdiction or not. Or suppose some ineligible person is appointed as minister, or he is wrongly removed against the provisions of the Constitution, whether the Supreme Court can interfere or not.
Your Lordship, the questions like if there is any means appointment which again and again appointment is made by the governor, in that case the Supreme Court can interfere. And in the case of S.R. Chaudhary versus Union of India, the same case was happened, means the appointments were again made by again and again made, but in that case Supreme Court can interfere. But in the instant case, Your Lordship, the means ministers were removed for the disgracing of office of the governor, and if the council seeks permission to read the article 159 of the constitution. Indeed, Your Lordship. It provides that every governor and every person discharging the functions of the governor before entering upon his office can subscribe in the presence of the Chief Justice of the High Court, exercising in relation to the jurisdiction in the relation to the state, or in the absence of the senior most judge of the court available on oath or affirmation in the following form, that is to say, and the formality, and then the language is
entirely different. The oath is different. Here the question is
whether
the removal of the ministers by the governor is constitutional or unconstitutional. That is the issue. In that case, whether the Supreme Court has got the power or not.
Your Lordship, the removal of the ministers by the governor in the instance case is totally constitutional.
It is for the court to decide. Whether in that case the Supreme Court has got the jurisdiction, there the minister saying that it is unconstitutional. Who will decide it then? Governor himself or somebody else? That's the issue.
Your Lordship,
Question?
I'm not.
Have you understood the question? No. The question is that they say it is not constitutional. You say it is constitutional. We have to have an umpire to say whether it is constitutional or not constitutional. Who will say so?
Your Lordship.
The governor, the chief minister, the president, the legislature, or the Supreme Court. Who will say it is constitutional or it is not constitutional?
Indeed, Your Lordship. Your Lordship, if means that the government were removed from their office, then they would have reviewed the decision of the governor before the president, who is the appointing authority of the governor, and under whose pleasure the governor continued to hold his office.
You are not getting the question. The question is very simple. One party says it is okay. The other party says it is not okay. Right?
Indeed.
Who will decide who is right? This side or this side? Who will decide?
The deciding authority, the bench.
Is the
Bench
of
the Honorable Court, Honorable Supreme Court.
Supreme Court. So that way Supreme Court has the power or no?
So in that case, means we should look to the jurisdiction of the Supreme Court. No?
Very simple question, very straight question. You are not answering the question. And I am sorry to say that a good advocate is that who carries the court along with him. And you are going this side, court is going that side. Where would you reach? Nowhere.
The council.
Don't you understand the question? Question is that petitioner says the removal of minister is all right. Respondent says it is not all right. Who will decide that which party is correct?
The
Supreme Court?
Yes.
So that doesn't mean that Supreme Court has the power to intervene? May intervene?
Your Lordship, Supreme Court may intervene in the matters of the appointments. Apology, Your Lordship.
Highly replies, Your Lordship. It is an honor for the Council to present before the Honorable Bench. May it please the Honorable Court, this is Council 2 pleading on the behalf of the respondent. The Council seeks permission to proceed further with the issue number 3 and 4, Your Lordship. Highly oblige, Your Lordship. Your Lordship, issue number 3 states that whether the governor has only a signing or has an active role to play in the parliamentary democracy. Your Lordship, it is humbly submitted before the Honorable Court that the governor is not a signing authority and has an active role to play in the democracy. Your Lordship, the argument is based on the premise that governor is an executive head of the state, as mentioned under Article 154, which states that the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through the subordinate to him in accordance with the Constitution. Your Lordship, further referring to the Article 159, which talks about the oath of the governor, which casts the duty upon him to preserve, to protect, and to defend the Constitution. Your Lordship, further it is contended that the notable exceptions for the governor, where he may not follow the aid and advice of the cabinet, as interpreted in many cases, as when the bias of the state government is inherent or apparent, as well as with the dissolution of the house, or where the decision of the state cabinet is wholly irrational, or where the cabinet, because of some incapacity, becomes disentitled for such giving some advice. Your Lordship, the above contention has been based on some provisions of the Constitution of Maurya that describes the discretionary power of the governor. Your Lordship, there shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his function, except in the discretion that has been provided by the Constitution. Second, if any question arises whether a matter is within the governor's discretion or not, the governor's decision shall be final. The discretion power of the governor is wider than that of the president, Your Lordship, as he enjoys both the constitutional as well as the situational discretion. Your Lordship, the constitutional discretion states that he shall be bound by the aid and advice of the Council of Ministers, whereas in the situational discretion, this is the absolute power in which he can act upon his own. That states that the governor can reserve the bill and send to the bill for the president's consideration. Article 356, that the governor can recommend the president to impose president rules on the failure of the constitutional machinery. Your Lordship, further, the governor is not bound to act on the aid and advice of the CM and the Council of Ministers while performing his duty as the administrator of the neighboring union territory in the case of the additional discharge that has been provided to him. Your Lordship, in the instant case, the governor has exercised his discretionary power and withdrawn the pleasure of the minister on the ground of disgracing the office of the governor. Your Lordship, it is humbly submitted. And it is based on the premise that the above argument is based on the premise that Article 163, Clause 2, that states that if any question arises, whether any matter is or not, as respect to the governor, as respect which the governor is by or under the Constitution is required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called upon the question on the ground that he ought or ought not to have been acted in his discretion. Your Lordship, in the case of Hardwari Lal versus G.D. Tapase, Your Lordship, in this case the petitioner was a member of the Haryana Legislative Assembly. On the request of the Chancellor, he resigned from the office and joined as the Vice Chancellor in the Kurukshetra University. He served for some years, and later the governor passed an ordinance that the maximum age for the vice chancellor should be 60 years or the 5 years, whichever be the maximum. Your Lordship, in this case, it was held that the act intended that the state government as such ought not to interfere in the affairs of the university, and the state government could not give advice to the governor in discharge of the functions as the chancellor in his capacity. The governor acts in his discretion and not on the aid and advice of the Council of Ministers, Your Lordship.
You have referred to Hardwari Lal's case.
Yes, sir.
In that case, the powers of the Chancellor were in question. Do you equate the Chancellor with the office of the Governor?
Your Lordship, it is an state university, so he is ex officio the Chancellor of the university.
That is right, he is ex officio the Chancellor.
Indeed.
But the powers of the Chancellor are akin to the powers of the Governor, or there is some difference?
Lordship, he is acting in his official capacity. Your Lordship, the council would like to refer the case law.
That case is all right. We want to be clear on this point, whether the office of the chancellor is equated with the office of the governor, or there is some difference between the two offices. We understand that chancellor acts under the particular act of the university, where under the university is constituted, and governor's office is under the Constitution of India. So how do we equate the two?
So the offices are different, but since he is the ex officio.
Ex officio is all right. Governor may be chancellor, governor may be chairman of some committee, governor may be holding many ex officio offices. So would all those offices would be covered by the powers of the governor, or the powers are separate from those of the governor?
Lordship, these are separate. Lordship.
Hello. You said that the chief minister is appointed by the governor and other ministers are appointed on the advice of the chief minister. So whether the governor can remove the other minister without the advice of the chief minister, if they are appointed on the advice of the chief minister, then certainly the advice of the chief minister is required to remove them.
Indeed, Your Lordship.
Even if the doctrine of player is applied in these cases. So what do you think about that? Whether the governor could do it without the advice of chief minister?
Lordship, the council seeks ignorance in this case. Council seeks ignorance in this case, Your Lordship. Indeed, Your Lordship.
My honorable friend has mentioned that there is a complete immunity given to governor regarding the functions of the governor in the Article 361. They have mentioned this in issue 1. And we want to refer to the proviso of the same article, that is 361. In that, it is clearly written that the judicial review of the powers of the governor, which is included in the government of state, can be done. And the second question is that in paragraph 5,
Please address the court, not the other side.
in paragraph 5, my honorable friend, Your Lordship, have mentioned the case of Mahabir Prasad Sharma versus Prafulla Chandra Bose and others, in which they have said that the powers of the governors are unrestricted. It is a case of 1969, Your Lordship, and after this case, various landmark judgments were decided, like Shamsher Singh versus State of Punjab, which is a case of 2005, which we have stated in the paragraph number 17 of our memorial, and other case is Nabam Rebia versus Deputy Speaker, which is a case of 2016, which we have mentioned in paragraph 22 of our memorial. In both the cases, it was held that discretion is not unfettered or unrestricted, it has limitation and is subject to judicial review. Position of the governor will be a super constitutional authority and will be above state executive and state legislature, which is not intended by our constitution. And the fourth question, Your Lordship, is under issue number 3, they have referred to Article 163(2), Your Lordship, and they themselves have contradicted their own argument. Article 163(2) uses two words, that is required and the other is by or under the Constitution. And both these phrases, the phrase required says that there has to be a compelling necessity, and by or under the Constitution clearly state that compelling necessity has to be under the provisions of the Constitution. So there is no such compelling necessity, and moreover there is that is not in the Constitution itself. So we want justification for that.
Now I request, please declare the results. Please pronounce the judgment, sir.
Which you have arrived at unanimously.
Yes. Mr. Anil Chopra, Chairman of the institution, Mr. Sharma, Director, members of the faculty, students and the participants. Believe me that it has been very difficult for us to judge the best of the second, because both the teams have been very good. They have pleaded their cases very well and have presented the arguments very well. Before I pronounce the judgment, I would like to make some comments for the benefit of the participants and of course for the consumption of the organizers of the Moot Court. First of all, I have attended many Moot Courts, but I am surprised to note one thing, that invariably in all the Moot Courts, the constitutional provisions are taken into consideration. To say it otherwise, that writ jurisdiction is available. But I feel that real advocacy lies in thrashing the evidence, in applying the provisions of CRPC, IPC, Evidence Act, and all other laws. So my suggestion to the management is that in one of the Moot Courts, please try to concentrate on a civil suit. The participant should be called upon to marshal evidence, to appreciate evidence, and to apply the provisions of law to the facts of the case. Because in writ courts, we have cooked up materials, the documents are there, we just refer to the constitutional provisions, and that is end of the matter. But real worth of an advocate comes out when he is able to catch something from the other side and use it to his own benefit. So that will come only when you thrash evidence, when you marshal evidence, when you appreciate evidence, and when you apply provisions of law to the facts of the case. Then certain you can say advices or comments about the participants. First of all, the participant should note that there is a difference between lecturing and arguing a case. Lecturing is one thing, that you have a subject and you just stand up before the audience and say whatever you want to say. But argument is that you have to convince the two people sitting there. And for that, you have to add something convincing to your arguments. I would not name the participants, but the participants have used the rostrum as if it is for the lecturing, not for arguments before a court. Arguments should be very slow, very lucid, and backed by law and precedents. First make the point, then supported by law and precedent defending. Then the participants were unnecessarily feeling obliged to the bench repeatedly. And I am reminded of a case of an advocate, rather I should say. We as advocates are very much in habit of saying my lord, and this is a factual position, that we had an advocate who would even split the words to add my lord in between. He would say consti my lord Chushan. And when he was arguing a case before the Chief Justice bench, then Chief Justice stopped him and asked that, Mr. Counsel, you have used my lord 360 times in your arguments. After taking my lord out, what is your net argument? And he said, nothing, my lord. So similarly, we have found that the participants here, they were being obliged to the bench unnecessarily and repeatedly. Make your points and be courteous. You need not be that obliged to the bench unnecessarily. And one of the participants, at the very outset, he says that I feel sorry for the mistakes, if any, in the memorial. Why should you feel sorry when no mistakes have been pointed out? Rather, by saying so, you are telling the bench that there are some mistakes in the memorial, and please be focused on those mistakes. We have to put forth our plus points. Then one participant, 2-3 times he pleaded ignorance about the legal provisions, and my brother was forced to intervene, and then I took over from him and referred to a judgment by Justice Rajiv Narayan Rana, wherein the Honorable Judge very particularly stated that judges can afford to be ignorant of law, but an advocate cannot. You are there to tell the judges what law is, and the judges then decide the cases on the basis of that law. Another very small point, that when you refer to a judgment, you need not refer to name of the judge. Some participants refer to Justice Mukherjee, but if at all you have to refer to the judge, then refer to respectfully. And the participant just said Justice Mukherjee. It is not that way that we refer to the judges. We say Honorable Judge or Mr. Justice. It has to be respectful. So these are some of the points that I have noted while hearing the arguments. And I feel that the participant will take note of these comments and will accordingly incorporate them whenever they are called upon to argue the matters. My brother also has some comments. Let him first tell his comments, then I will pronounce the judgment.
So I think on a different note, we are dealing with the students who are just to begin their career. I will appreciate that though I think the students, they are not final year students, but they made very good effort. It is a very good beginning. In the beginning, there might be mistakes. You learn from the mistakes and then you rise. I appreciate that both the teams made very good efforts, taking into consideration their level. They are not professional liars. So they made very good efforts. Sometimes it so happens that you have got a weak case. You can't do anything with a dead man. If somebody is dead, you can't inject anything, injection of glucose and say it won't help. So sometimes you have got a weak case, but even then, on one or the other point, the provisions are against one or the other party, but even then they made best efforts to convince the bench, one or the other way, that they have got a point. Regarding the maintainability of the petitions, I would say that the governor is the citizen of India, and there are instances when a speaker of the house has approached the courts. So I think if the same position is constitutional position is taken, the governor, if some constitutional provisions are violated, in certain circumstances, court may allow him to approach the court and get that illegality rectified. So all of them made very good efforts. Keep it up, improve it, and next time you will see that when you pass out the law course, you will become very good liar and take the practical considerations also. So when you have got a weak case, yesterday I pointed out that the old man was asking for a stay. He had lost in all the 3 courts below. So judge said, no, you have lost. I repeat it again. You have lost the case, so it is not maintainable here. You can't do it. So the liar said, look, my lord, he is 85-year-old. He has only few years to live. So where he will go if he is thrown out of the house? So please allow him few years. Thereafter, we don't mind where the house goes. So he was right also. The judge said, okay. For the time being, it is stay till the next hearing. So if you have got a weak case, you can resort to the practical arguments to convince the court that practically you need the relief, maybe for a limited period. Thank you very much. Now the
Yes. Before pronouncing the result, I must say that the team that wins should not feel that this is the end of the road for them or they have reached the top. Only sky is the limit. You have to strive further. And the team that comes runner-up, they should not feel that they have lost everything. This is only a reminder to them that you have to put in a bit of more labor. With these remarks, I announce the judgment which we both have reached unanimously. As far as team is concerned, we find that team 502 is the winner. And as regards the best mooter, it is shared by 2. first mooter in the first team and second mooter in the second team. First mooter. The spectacled girl. Yes. And second mooter in the second team. Yes. Thank you.
For presiding the final round of the day. Winning team 502, it's Sharda University. Runner-up team RC 507, it's GNDU Guru Nanak Dev University, Amritsar. Best researcher, which is based on the evaluation of memorial, RC 506, UILS, Chandigarh. Congratulations to all the participating teams. Now I request our honorable judges, who are the chairman sir, director sir, MD sir, Veena Dada ma'am, to present trophies to our winning team, runner-up team, best mooter, best researcher. A big round of applause for best researcher with cash prize of 2100 rupees.
सारी साइड मैम इस साइड देखियो.
Best student advocate. Best student advocate from team 507.
कट डाउन कर.
Best student advocate RC 502 team. Again with cash prize.
सारी साइड देखिए शर्मा सर.
So that is now able to decide.
Now it's a time for the runner-up trophy. 507 Guru Nanak Dev University, Amritsar, with cash prize of 5100.
सर थोड़ा कर लेना सर चौकस. अनिल सर सर थोड़ा क्या तुझे सर क्या तुझे सर थोड़ा डाउन करियो फेस टॉप पे.
Now it's the turn of winning team. That is 502 Sharda University with cash prize of 11,000. Congratulations to all participants.
सर ट्रॉफी थोड़ी डाउन. सर इस साइड देखिए. मैम इस साइड. मैम इस साइड देखियो. मैम कैमरा बेस.
Congratulations for your commendable responses. Now I request Honorable Justice Kuldeep Singh Ji, Justice M.S. Chauhan Ji, worthy Chairman Sir, Director Sir, MD Sir, to present mementos to honor our judges of preliminary round pre-quarter, quarter-final, semi-final, because without their contribution we cannot conclude this event. I invite Shri B.J. Nangli ji, retired district and session judge. A big round of applause for our judges also.
Sharma sir.
Professor Pawan Kumar Bhatia ji, Professor and Head Department of Laws, Amritsar. Sir, we congratulate to you also.
Sir, इस साइड देखियो.
Professor Ruby.
मैम इस साइड देखियो सारे. मैम सामने देखियो.
I also request our guests to accolade our participating teams by giving them certificates and mementos. Team RC501, ICFAI University, please come forward, all the 3 team members. (502) Sharda University, we will provide you winning certificates also. RC 503 Sidling School of Law, Jaipur. Yes, sir. Jaipur. Sidling School of Law, Jaipur. Sidling School of Law. Just wait. Next, Sidling School of Law. Sharda University. UPES, Dehradun.
सर सामने ध्यान दियो सारे.
GNDU Regional Campus Laddewali.
मैम सामने ध्यान दियो सारे.
KCL Amritsar. Dr. B.R. Ambedkar Law University, Chennai. GNDU Regional Campus. KIIT School of Law, Bhubaneswar.
सामने ध्यान दियो.
Odisha की टीम. KCL Amritsar. KIIT School of Law, Bhubaneswar, Odisha. Maharashtra National Law University, Nagpur. Maharashtra National Law University, Nagpur.
सर सामने देखियो. सर इस साइड देखियो.
It's Maharashtra. Maharashtra 523. 523. Himachal Pradesh National Law University, Shimla. Himachal Pradesh National Law University Shimla, Saint Soldier Law College Jalandhar, SS Manyar Law College, Jalgaon, Maharashtra, Saint Soldier Law College Jalandhar, SS Manyar Law College, SS Manyar College,
सारी साइड देखियो
Congratulations to all the participating teams. Thank you all. Now I request our worthy Chairman Sir, MD Sir, Director Sir to honor our Chief Guest, Honorable Justice Kuldeep Singh Ji with a token of love. I also request worthy Chairman Sir, Director Sir to honor our guest of the day, Honorable Justice MS Chauhan Ji. Yes.
सारी साइड देखियो
It's the time to honor our Honorable Justice MS Chauhan Ji. A big round of applause for our judges because it was very neck-to-neck competition in final round. Thank you all the jury member as well as all the persons. Have your seats over sofas.
Thank you is such a prayer that cannot be seen or touched. It must be felt by heart. I feel honored and privileged to get the opportunity to propose a vote of thanks on 11th RC Memorial Moot Court Competition. I would like to thank our Honorable Chief Guests, Mr. Justice MS Chauhan and Mr. Justice Kuldeep Singh for gracing this occasion. I also extend my gratitude towards all the invited guests, participating teams, mooters. I would like to thank our worthy chairman, Dr. Anil Chopra ji, for their constant support. I'm also very thankful to Managing Director, Professor Manhar Arora ji, and Campus Director, Mrs. Veena Dada ji, and principals and directors of all colleges of Saint Soldier Group. I would like to thank our beloved Director of Saint Soldier Law College, Professor Dr. Subhash Sharma, for his constant help and guidance that radiates a source of energy within us. I am very thankful to all our current and formal faculty, colleagues, and non-teaching staff members who always stand by us. An event of this dimension cannot happen overnight. The wheels start rolling months in advance. We have been fortunate enough to be backed by a team of very motivated and dedicated students, committee, volunteers. I cannot thank everyone enough for the involvement they have shown and the willingness they have expressed to take on the completion of tasks beyond their comfort zone. I am very much thankful to the transportation and accommodation team. Without you guys, this event was not possible. Thank you. If time is money, then today you have spent millions for us. Thanks to all of you for making this event successful. Thank you everyone. Jai Hind.
ਸੋ ਸਾਡੇ ਨਾਲ ਮੈਨੇਜਿੰਗ ਡਾਇਰੈਕਟਰ ਮਨਹਰ ਅਰੋੜਾ ਜੀ ਖੜੇ ਨੇ। ਸੋ ਉਹਨਾਂ ਨੇ ਅੱਜ ਜੋ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਪੁੱਛਣਾ ਚਾਹਾਂਗੇ ਕਿ ਕਿਵੇਂ ਦਾ ਲੱਗਿਆ ਉਹਨੂੰ। ਸਰ ਬਹੁਤ ਬਹੁਤ ਸਵਾਗਤ।
ਸੇਂਟ ਸੋਲਜਰ ਟਾਈਮਸ ਦੇਖਣ ਵਾਲੇ ਸਾਰੇ ਹੀ ਦਰਸ਼ਕਾਂ ਨੂੰ ਮੇਰਾ ਪਿਆਰ ਭਰਾ ਨਮਸਕਾਰ, ਸਤਿ ਸ਼੍ਰੀ ਅਕਾਲ, ਆਦਾਬ। ਅੱਜ 11ਵਾਂ ਸ਼੍ਰੀ ਆਰ.ਸੀ. ਚੋਪੜਾ ਮੈਮੋਰੀਅਲ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਜਿਹੜਾ ਸੀਗਾ ਸੇਂਟ ਸੋਲਜਰ ਲਾਅ ਦੇ ਵਿੱਚ ਕਰਾਇਆ ਗਿਆ। ਇਹ 2 ਦਿਵਸੀਏ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਸੀਗਾ, ਜਿਹਦੇ ਵਿੱਚ ਪੂਰੇ ਭਾਰਤ ਵਰਸ਼ ਦੀਆਂ 32 ਟੀਮਾਂ ਨੇ ਇਹਦੇ ਵਿੱਚ ਹਿੱਸਾ ਲਿਆ ਸੀਗਾ। ਔਰ ਇਹ ਬਹੁਤ ਹੀ ਵੱਡਾ ਇੱਕ ਆਯੋਜਨ ਸੀਗਾ ਕਿ ਜਦੋਂ ਜਿਸ ਵਿੱਚ ਵੱਖਰੀ ਲਾਅ ਯੂਨੀਵਰਸਿਟੀਜ਼, ਲਾਅ ਕਾਲਜਿਸ ਦੇ ਜਿਹੜੇ ਵਿਦਿਆਰਥੀ ਸੀਗੇ ਉਹਨਾਂ ਨੇ ਇਹਦੇ ਵਿੱਚ ਪਾਰਟਿਸਿਪੇਟ ਕਰਕੇ ਆਪਣੀ ਜਿਹੜੀ ਪ੍ਰਤਿਭਾ ਸੀਗੀ ਉਹਨੂੰ ਸਾਰਿਆਂ ਨੇ ਦਿਖਾਇਆ। ਤੇ ਸਭ ਤੋਂ ਵੱਡੀ ਜਿਹੜੀ ਚੀਜ਼ ਰਹੀ ਸਾਡੇ ਕੋਲ ਅੱਜ ਮੇਨ ਮੁੱਖ ਮਹਿਮਾਨ ਦੇ ਤੌਰ ਦੇ ਉੱਤੇ 2 ਹਾਈ ਕੋਰਟ ਦੇ ਜੱਜਸ ਆਨਰੇਬਲ ਜਸਟਿਸ ਕੁਲਦੀਪ ਸਿੰਘ ਜੀ ਤੇ ਆਨਰੇਬਲ ਜਸਟਿਸ ਸ਼੍ਰੀ M.S. ਚੌਹਾਨ ਜੀ, ਜਿਹੜੇ ਕਿ ਬਹੁਤ ਹੀ ਲੀਡਿੰਗ ਜੱਜਸ ਰਹੇ ਨੇ ਆਪਣੇ ਸਮੇਂ ਦੇ ਔਰ ਹਾਲੇ ਵੀ ਆਪਣੇ ਜਿਹੜੀ ਸੇਵਾਵਾਂ ਉਹ ਦੇ ਰਹੇ ਨੇ। ਉਹਨਾਂ ਨੇ ਆ ਕੇ ਬੱਚਿਆਂ ਦੇ ਜਿਹੜੇ ਮੂਟ ਕੋਰਟ ਦਾ ਫਾਈਨਲ ਸੀਗਾ ਉਹਨੂੰ ਉਹਨਾਂ ਨੇ ਦੇਖਿਆ, ਉਹਨਾਂ ਦੇ ਵਿੱਚ ਆਪਣੀ ਰਿਵਿਊਜ਼ ਦਿੱਤੇ ਤੇ ਉਹਨਾਂ ਨੂੰ ਆਪਣੇ ਜਿਹੜੇ ਜਾਣਕਾਰੀਆਂ ਵੀ ਦਿੱਤੀਆਂ ਕਿ ਕਿਸ ਤਰੀਕੇ ਦੇ ਨਾਲ ਉਹ ਹੋਰ ਅੱਗੇ ਆਪਣੇ ਪ੍ਰੋਫੈਸ਼ਨ ਦੇ ਵਿੱਚ ਵੱਧ ਸਕਦੇ ਨੇ। ਇਹਦੇ ਵਿੱਚ ਸ਼੍ਰੀ ਅਨਿਲ ਚੋਪੜਾ ਜਿਹੜੇ ਚੇਅਰਮੈਨ ਸਾਹਿਬ ਨੇ ਉਹਨਾਂ ਨੇ ਵੀ ਸ਼ਿਰਕਤ ਕੀਤੀ। ਉਹਨਾਂ ਨੇ ਵੀ ਆਪਣੇ ਬੱਚਿਆਂ ਦੇ ਕੰਮ ਨੂੰ ਸਰਾਹਿਆ, ਆਪਣੇ ਬੱਚਿਆਂ ਦੇ ਟੈਲੈਂਟ ਨੂੰ ਸਰਾਹਿਆ ਤੇ ਜਿਹੜੇ ਸਾਡੇ ਮੁੱਖ ਮਹਿਮਾਨ ਆਏ ਸੀਗੇ ਉਹਨਾਂ ਨੂੰ ਸਨਮਾਨ ਚਿੰਨ੍ਹ ਦੇ ਕੇ ਉਹਨਾਂ ਨੂੰ ਸਨਮਾਨਿਤ ਕੀਤਾ। ਤੇ ਜਿਹੜੇ ਵੀ ਹੋਰ ਬਾਕੀ ਵੀ ਟੀਮਾਂ ਆਈਆਂ ਸੀਗੀਆਂ, ਜਿਹੜੇ ਫਸਟ ਜਿਹੜੀ ਟੀਮ ਆਈ ਹੈ ਉਹ ਸ਼ਾਰਦਾ ਯੂਨੀਵਰਸਿਟੀ ਦੀ ਆਈ ਹੈ ਤੇ ਦੂਸਰੀ ਜਿਹੜੀ ਟੀਮ ਹੈ ਉਹ ਗੁਰੂ ਨਾਨਕ ਦੇਵ ਯੂਨੀਵਰਸਿਟੀ ਦੀ ਟੀਮ ਆਈ ਹੈ। ਰਨਰਸ ਅਪ ਜਿਹੜੇ ਆਏ ਨੇ ਔਰ ਇਸ ਤੋਂ ਇਲਾਵਾ ਵੀ ਬਾਕੀ ਸਾਰੇ ਪੰਜਾਬ, ਹਰਿਆਣਾ, ਉੱਤਰ ਪ੍ਰਦੇਸ਼, ਉੜੀਸਾ, ਮਹਾਰਾਸ਼ਟਰਾ, ਕਰਨਾਟਕਾ, ਕੇਰਲਾ, ਚੰਡੀਗੜ੍ਹ, ਦਿੱਲੀ, ਇਹ ਸਾਰੀਆਂ ਸਟੇਟਸ ਦੇ ਵਿੱਚੋਂ ਜਿਹੜੇ ਬੱਚੇ ਆਏ ਸੀਗੇ ਉਹਨਾਂ ਨੇ ਭਰਪੂਰ ਇਹਦਾ ਜਿਹੜਾ ਸੀਗਾ ਫ਼ਾਇਦਾ ਉਠਾਇਆ ਔਰ ਉਹਨਾਂ ਨੇ ਸ਼ਲਾਘਾ ਕੀਤੀ ਕਿ ਇਹ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਜਿਹੜਾ ਸੀਗਾ ਔਰ ਖ਼ਾਸ ਤੌਰ 'ਤੇ ਮੂਟ ਜਿਹੜੀ ਪ੍ਰੋਬਲਮ ਦਿੱਤੀ ਗਈ ਸੀ ਉਹ ਬੜੀ ਵਧੀਆ ਬੜੀ ਵਧੀਆ ਜਿਹੜੀ ਪ੍ਰੋਬਲਮ ਸੀਗੀ, ਜਿਹਨੂੰ ਪੜ੍ਹ ਕੇ ਜਾਂ ਜਿਹਨੂੰ ਡੀਲ ਕਰਕੇ ਐਜ਼ ਅ ਪਟੀਸ਼ਨਰ, ਐਜ਼ ਅ ਰਿਸਪੋਂਡੈਂਟ ਦੋਨੋਂ ਤਰੀਕਿਆਂ ਨਾਲ ਕਰਕੇ ਉਹਨਾਂ ਨੂੰ ਬਹੁਤ ਹੀ ਫ਼ਾਇਦਾ ਲੱਭਿਆ। ਤੇ ਇੱਕ ਬਹੁਤ ਹੀ ਵੱਡਾ ਆਯੋਜਨ ਰਹਿੰਦਾ ਹੈ ਔਰ ਅਸੀਂ ਹਰ ਸਾਲ ਇਹਨੂੰ ਕਰਦੇ ਰਹਿੰਦੇ ਹਾਂ ਔਰ ਇਹਦੇ ਵਿੱਚ ਬੱਚਿਆਂ ਨੂੰ ਰੀਅਲ ਲਾਈਫ ਦੇ ਵਿੱਚ ਕਿੱਦਾਂ ਕੋਰਟ ਦੇ ਵਿੱਚ ਅਸੀਂ ਆਪਣੇ ਆਪ ਨੂੰ ਪ੍ਰੈਜ਼ੈਂਟ ਕਰੀਦਾ ਹੈ, ਕੋਰਟ ਦੇ ਵਿੱਚ ਕਿੱਦਾਂ ਕੋਈ ਕੇਸਿਸ ਲੜੀਦੇ ਨੇ, ਕੋਰਟ ਦੇ ਵਿੱਚ ਕਿਸ ਤਰੀਕੇ ਦੇ ਨਾਲ ਜੱਜ ਸਾਹਿਬਾਂ ਦੇ ਨਾਲ ਆਪਾਂ ਇੰਟਰੈਕਸ਼ਨ ਕਰੀਦੀ ਹੈ, ਕਿਹੜੇ ਟੈਕਨੀਕਲ ਵਰਡਸ ਦਾ ਇਸਤੇਮਾਲ ਕੀਤਾ ਜਾਂਦਾ ਹੈ, ਇਹ ਸਾਰੀਆਂ ਚੀਜ਼ਾਂ ਉਹਨਾਂ ਨੂੰ ਆਪਸ ਦੇਖਣ 'ਤੇ ਮਿਲਦੀਆਂ ਹੈ। ਤੋ ਸਾਡਾ ਸੇਂਟ ਸੋਲਜਰ ਲਾਅ ਕਾਲਜ ਦਾ, ਸੇਂਟ ਸੋਲਜਰ ਗਰੁੱਪ ਆਫ ਇੰਸਟੀਟਿਊਸ਼ਨਸ ਦਾ ਇਹ ਮਕਸਦ ਰਹਿੰਦਾ ਹੈ ਕਿ ਬੱਚਿਆਂ ਨੂੰ ਪੜ੍ਹਾਈ ਜਿਹੜੀ ਹੈ ਨਾ ਪ੍ਰੈਕਟੀਕਲ ਤੌਰ 'ਤੇ ਮਿਲੇ, ਤਾਂ ਕਿ ਜੋ ਪੜ੍ਹਾਈ ਕਰਨ ਤੋਂ ਬਾਅਦ ਪਾਸ ਹੋਣ ਤੋਂ ਬਾਅਦ ਜਿੱਦਾਂ ਦਾ ਕੰਮ ਉਹਨਾਂ ਨੇ ਕਰਨਾ ਹੈ ਉਹਨਾਂ ਨੂੰ ਉੱਦਾਂ ਦਾ ਇਨਵਾਇਰਨਮੈਂਟ ਦਿੱਤਾ ਜਾਵੇ ਤਾਂ ਕਿ ਉਹ ਬਾਹਰ ਜਾ ਕੇ ਉਹਨਾਂ ਨੂੰ ਬਿਲਕੁਲ ਹੀ ਓਪਰਾਪਨ ਨਾ ਲੱਗੇ।
ਥੈਂਕ ਯੂ। ਸੋ ਅੱਜ ਸੇਂਟ ਸੋਲਜਰ ਲਾਅ ਕਾਲਜ ਦੇ ਵਿੱਚ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਰੱਖਿਆ ਗਿਆ। ਉਹਦੇ ਵਿੱਚ ਬਹੁਤ ਸਾਰੇ ਬੱਚਿਆਂ ਨੇ ਆਪਣੀ ਇੱਕ ਪ੍ਰਤਿਭਾ ਨੂੰ ਜ਼ਾਹਿਰ ਕੀਤਾ। ਤਾਂ ਕੁਝ ਬੱਚੇ ਜੋ ਕਿ ਆਪਣੇ ਇਸ ਟੈਲੈਂਟ ਦੇ ਵਿੱਚ ਅੱਗੇ ਆਏ ਨੇ ਉਹਨਾਂ ਦੇ ਨਾਲ ਕਰਨੀ ਚਾਹਾਂਗੇ ਗੱਲਬਾਤ, ਕੀ ਕਹਿਣਾ ਹੈ ਉਹਨਾਂ ਦਾ। ਸਤਿ ਸ਼੍ਰੀ ਅਕਾਲ।
ਸਤਿ ਸ਼੍ਰੀ ਅਕਾਲ।
ਕਿੱਥੋਂ ਆਏ ਵੈਸੇ ਤੁਸੀਂ?
ਗੁਰੂ ਨਾਨਕ ਦੇਵ ਯੂਨੀਵਰਸਿਟੀ ਅੰਮ੍ਰਿਤਸਰ ਸੇ
ਜੀ। ਜਿਹੜਾ ਅੱਜ ਦਾ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਸੀਗਾ ਉਹਦੇ ਵਿੱਚ ਕਿੱਦਾਂ ਦੇ ਤੁਹਾਨੂੰ ਮਤਲਬ ਸਵਾਲ ਜਵਾਬ ਕੀਤੇ ਗਏ, ਕਿਵੇਂ ਤੁਸੀਂ ਆਪਣੇ टैलेंट ਨੂੰ ਅੱਗੇ लेके आए?
सवाल जवाब ऑब्वियसली जस्टिस आए हुए थे वहाँ पे, तो वैसे ही सवाल जवाब थे उनके, तो टफ़ था कंपटीशन भी, बट चलो हमने जितनी तैयारी करी थी तो उस हिसाब से हमने अपना बेस्ट देने की कोशिश करी है। बहुत अच्छा, मतलब सेंट सोल्जर का स्टाफ भी बहुत अच्छा, फैकल्टी, हम 1-2 दिन पहले आए थे तो हॉस्पिटैलिटी इनकी बहुत अच्छी थी, तो इट वाज रियली गुड।
थैंक यू व्हाट योर नेम
ਅਵਨੀਤ ਕੌਰ
ओके क्या कहना चाहेंगे
ਬਹੁਤ ਵਧੀਆ ਸੀ ਸਾਰਾ ਕਿਉਂਕਿ ਬਹੁਤ ਫੈਕਲਟੀ ਜੋ ਹੈ ਬਹੁਤ ਹਸਪਿਟੇਬਿਲਿਟੀ ਉਹਨਾਂ ਨੇ ਦਿਖਾਈ ਐਂਡ ਅਸੀਂ ਕੱਲ ਆ ਚੁੱਕੇ ਸੀ ਐਂਡ ਉਹਨਾਂ ਨੇ ਸਭ ਕੁਝ ਬਹੁਤ ਅੱਛੇ ਤਰੀਕੇ ਨਾਲ ਮੈਨੇਜ ਕੀਤਾ ਐਂਡ ਜੋ ਅੱਜ ਜੱਜਿਸ ਆਏ ਸੀ ਉਹਨਾਂ ਨੇ ਬਹੁਤ ਅੱਛੇ ਓਪੀਨੀਅਨਸ ਦਿੱਤੇ ਜੋ ਕਿ ਡੈਫੀਨੇਟਲੀ ਸਾਡੇ ਅੱਗੇ ਜਾ ਕੇ ਕੰਮ ਆਣਗੇ ਸੋ ਇਟ ਵਾਸ ਵੈਰੀ ਗੁੱਡ ਥੈਂਕ ਯੂ
ਤੇ ਜੋ ਤੁਸੀਂ ਅੱਜ ਇਹ ਮਤਲਬ ਅਚੀਵ ਕੀਤਾ ਹੈ ਟਰਾਫੀਜ਼ ਮਿਲੀ ਹੈ ਕਿਸ ਪਰਪਸ ਲਈ ਮਿਲੀ ਹੈ ਮੇਨ ਉਸੇ ਟੌਪਿੰਗ ਨੂੰ ਲੈ ਕੇ ਜਾਂ ਕੁਝ ਖਾਸ ਡਿਫਰੈਂਟ ਕੀਤਾ ਤੁਸੀਂ
ਓਕੇ ਇੱਕ ਟਰੋਫੀ ਸਾਡੀ ਟੀਮ ਨੂੰ ਮਿਲੀ ਹੈ ਬੈਸਟ ਮੂਟਰ ਦੇ ਲਈ ਜੋ ਕਿ ਜਿਹਨੇ ਸਭ ਤੋਂ ਅੱਛਾ ਬੋਲਿਆ ਜਾਂ ਸਭ ਤੋਂ ਵਧੀਆ ਆਪਣੇ ਆਰਗੂਮੈਂਟਸ ਪ੍ਰੈਜ਼ੈਂਟ ਕੀਤੇ ਉਹਦੇ ਲਈ ਦਿੱਤੀ ਜਾਂਦੀ ਹੈ ਐਂਡ ਦੂਸਰੀ ਜੋ ਫੈਕਟਸ ਐਸਟੈਬਲਿਸ਼ ਕੀਤੇ ਆ ਅਸੀਂ ਕੇਸ ਦੇ ਵਿੱਚ ਉਹਦੇ ਅਕੋਰਡਿੰਗਲੀ ਜੋ ਸੈਕਿੰਡ ਰਨਰ ਅਪ ਦਾ ਜੋ ਅਵਾਰਡ ਹੈ ਸਾਨੂੰ ਦਿੱਤਾ ਗਿਆ
ਜੀ ਕੀ ਕਹਿਣਾ ਚਾਹੋਗੇ
मैं क्या कहूँ सब अच्छा ही था एक्सपीरियंस भी अच्छा रहा यहाँ के फर्स्ट एक्सपीरियंस था हमारा मूट कोर्ट का
ਸੋ ਪੰਜਾਬ ਯੂਨੀਵਰਸਿਟੀ ਚੰਡੀਗੜ੍ਹ ਦੇ ਬੱਚੇ ਸਾਡੇ ਨਾਲ ਜੁੜ ਚੁੱਕੇ ਨੇ ਤੇ ਕਰਦੇ ਹਾਂ ਉਹਨਾਂ ਦੇ ਨਾਲ ਗੱਲਬਾਤ ਬਹੁਤ ਬਹੁਤ ਸਵਾਗਤ
ਥੈਂਕ ਯੂ ਸੋ ਮਚ ਮੈਮ
ਕੀ ਨਾਮ ਹੈ ਤੁਹਾਡਾ
ਰੂਹਾਨੀ
ਓਕੇ ਰੋਹਾਨੀ ਜੀ ਕਿਵੇਂ ਦਾ ਲੱਗਿਆ ਅੱਜ ਦਾ ਇਹ ਖਾਸ ਕੰਪੀਟੀਸ਼ਨ
ਬਹੁਤ ਵਧੀਆ ਕੰਪੀਟੀਸ਼ਨ ਸੀ ਤੇ ਕੰਪੀਟੀਟਿਵ ਟੀਮ ਸੀ ਇੱਥੇ ਵੀ ਫੈਲਟ ਇਟ ਵਾਸ ਅ ਓਵਰਆਲ ਐਂਡ ਵੈਰੀ ਗੁੱਡ ਕੰਪੀਟੀਸ਼ਨ
ਜੀ ਕਿਸ ਤਰ੍ਹਾਂ ਦੇ ਕੁਐਸਚਨ ਸੀਗੇ
ਕੁਐਸਚਨਸ ਵਰ ਲਾਈਕ ਬੇਸਿਕ ਇਨ ਦ ਫਰਸਟ 2 ਰਾਊਂਡਸ ਬੇਸਿਕਲੀ ਤੇ ਅੱਗੇ ਜਿਵੇਂ ਆਪਾਂ ਸੈਮੀਫਾਈਨਲਸ 'ਚ ਗਏ ਸੀ ਤੇ ਉੱਥੇ ਥੋੜ੍ਹੇ ਜਿਹੇ ਕੁਐਸਚਨ ਸੀ ਟਫ ਸੀਗੇ ਹਾਂਜੀ ਬਿਲਕੁਲ
ਤੇ ਜਿਹੜੀ ਟਰਾਫੀ ਮਿਲੀ ਹੈ ਕਿਸ ਪਰਪਸ ਲਈ ਮਿਲੀ ਹੈ
ਇਹ ਮਿਲੀ ਹੈ ਬੈਸਟ ਰਿਸਰਚਰ ਲਈ
ਵੈਰੀ ਨਾਈਸ ਹਾਂਜੀ ਕੀ ਕਹਿਣਾ ਚਾਹੋਗੇ
I am the speaker too, Sukhmani Kaur. It is my first moot. Like it was, and we did great job. That's it.
ਸੋ ਬੱਚੇ ਕਾਫੀ ਹੈਪੀ ਨੇ ਔਰ ਬੱਚੇ ਬਹੁਤ ਖੁਸ਼ ਨੇ ਨਜ਼ਰ ਵੀ ਆ ਰਹੇ ਨੇ ਸੋ ਬਹੁਤ ਕਹਿਣਾ ਉਹਨਾਂ ਦਾ ਇਹ ਹੈ ਕਿ ਅੱਜ ਜੋ ਕੰਪੀਟੀਸ਼ਨ ਸੀ ਸਾਨੂੰ ਅੱਗੇ ਜਾ ਕੇ ਬਹੁਤ ਜ਼ਿਆਦਾ ਇਸ ਦਾ ਬੈਨੀਫਿਟ ਮਿਲਣ ਵਾਲਾ ਹੈ ਬਿਕੋਜ਼ ਇਹ ਸਾਡਾ ਕੈਰੀਅਰ ਹੈ ਸਰ ਕੀ ਕਹਿਣਾ ਚਾਹੁੰਦੇ ਹੋ
ਮੈਂ ਸਨਪ੍ਰੀਤ ਸਿੰਘ ਫਰੋਮ 4th ਈਅਰ UILS ਤੋਂ ਤੇ ਇਹਦੇ ਵਿੱਚ ਮੈਨੂੰ ਬਹੁਤ ਵਧੀਆ ਲੱਗਾ ਕਿ ਜਿਹੜੇ ਫਾਈਨਲ ਰਾਊਂਡ ਸੀ ਤੋਂ ਬਹੁਤ ਕੁਝ ਸਿੱਖਣ ਨੂੰ ਮਿਲਿਆ ਆਨਰੇਬਲ ਜਸਟਿਸ ਦਾ ਬੈਂਚ ਬੈਠਿਆ ਤਾਂ ਉੱਥੋਂ ਬਹੁਤ ਕੁਝ ਸਿੱਖਣ ਨੂੰ ਮਿਲਿਆ ਕੁਝ ਕਮੀਆਂ ਕਰਕੇ ਅਸੀਂ ਵੀ ਨਹੀਂ ਪਹੁੰਚ ਸਕੇ ਪਰ ਸਾਨੂੰ ਸਿੱਖਣ ਨੂੰ ਬਹੁਤ ਕੁਝ ਮਿਲਿਆ ਇਹ ਕੰਪੀਟੀਸ਼ਨ ਹਮੇਸ਼ਾ ਆਰਗੇਨਾਈਜ਼ ਹੋਣਾ ਚਾਹੀਦਾ ਤੇ ਹਮੇਸ਼ਾ ਅੱਗੇ ਤੋਂ ਵੀ ਅਸੀਂ ਪਾਰਟਿਸਿਪੇਟ ਕਰਦੇ ਰਹਾਂਗੇ
ਜੀ ਕੀ ਕਹਿਣਾ ਚਾਹੋਗੇ ਸੇਂਟ ਸੋਲਜਰ ਲਈ
ਕਾਲਜ ਬਹੁਤ ਵਧੀਆ ਸੀ ਕੈਂਪਸ ਬਹੁਤ ਸੁੰਦਰ ਸੀ ਐਂਡ ਅਕੋਮੋਡੇਸ਼ਨ ਬਹੁਤ ਵਧੀਆ ਸੀ ਤੇ ਖਾਣਾ ਪੀਣਾ ਮਤਲਬ ਜੋ ਵੀ ਅਰੇਂਜਮੈਂਟ ਕੀਤਾ ਗਿਆ ਬਹੁਤ ਵਧੀਆ ਸੀ ਤੇ ਜਿਵੇਂ ਟੀਮਸ ਇੰਨਾ ਵਧੀਆ ਲੈਵਲ ਸੀ ਤੇ ਸਾਨੂੰ ਬਹੁਤ ਵਧੀਆ ਲੱਗਿਆ ਬਹੁਤ ਚੰਗਾ ਸੀ ਤੇ ਅਸੀਂ ਅੱਗੇ ਵੀ ਪਾਰਟਿਸਿਪੇਟ ਕਰਦੇ ਰਹਾਂਗੇ
ਵੈਰੀ ਨਾਈਸ
Even the coordinators were very good. The coordinators were also very good. They are very helpful.
रोहन सर बहुत अच्छे थे उन्होंने सारा ऑर्गेनाइज कराया हमेशा थे मतलब हमारे मतलब बहुत अच्छे थे
ਜੀ ਸੋ ਅੱਜ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਦੇ ਵਿੱਚ ਬੱਚਿਆਂ ਦੀ ਪ੍ਰਤਿਭਾ ਬਿਲਕੁਲ ਨਿਖਰ ਕੇ ਸਾਹਮਣੇ ਆਈ ਹੈ ਔਰ ਬੱਚਿਆਂ ਦਾ ਕਹਿਣਾ ਇਹ ਹੈ ਕਿ ਹਰ ਚੀਜ਼ ਸਾਡੇ ਲਈ ਬਹੁਤ ਵਧੀਆ ਸੀ ਬਣੇ ਰਹੋ ਜੀ ਸੇਂਟ ਸੋਲਜਰ ਟਾਈਮਸ ਵਿੱਚ ਕੈਮਰਾਮੈਨ ਵਿਨੋਦ ਦੇ ਨਾਲ ਐਂਕਰ ਕੋਮਲ ਸ਼ਰਮਾ